Ron Castille was the author of the decision that threw out the pay raise of 2005. And while that may sound like a good thing, you have to remember a couple of other things. First, he only threw it out for legislators in the executive branch. That decision allowed judges to keep the pay raise. And the other thing is that it allowed legislators to keep their unvouchered expenses, even though the decision said that unvouchered expenses were unconstitutional. That's like telling a bank robber, okay, you're guilty of robbing the bank, but you can keep the money. It shouldn't work that way. And that decision marked only the second time in the history of American jurisprudence that a law was not struck down in its entirety when it had a clause that said it had to be if part of it was declared unconstitutional. The very much larger picture, though, is how the court interprets our Constitution in the way the legislature passes legislation. And I'm going to make a sidetrack here and talk about three different provisions. One is called the single subject rule. It says that if you have a bill, it can contain only one subject. If you have more than one subject, you need more than one bill. The second rule in the Constitution is called the original purpose rule. You have to introduce a bill to do one purpose, and you cannot change that. It has to remain the same purpose as it goes through the legislative process. Otherwise, it's like bait and switch in consumer law. You can't do it. And then the third provision says that each bill has to be considered on 3 different days in the House and 3 different days in the Senate. Well, Pennsylvania became the slot machine capital of the East Coast in 2004 in a way that violated all of these provisions of the Constitution, and I'll show you exactly how it happened. This is the original bill that was introduced that became the slots gambling law, and you can see it's a page and a half long. It had to do with background checks for employees at horse tracks. This bill was considered for 47 days in the House and passed without amendment. It then was considered for 100 days in the Senate and passed with this amendment. 146 pages that had never been seen before by the public. It was inserted into the bill and passed and signed into law in a matter of hours, and the public never had any chance to know what was in it. And this is every word that the two versions have in common. These are not words, they are the sponsors, the legislators who sponsored this travesty. In other words, this is every word that actually got 3 different days of consideration in the House and 3 different days of consideration in the Senate. This is every word of the original purpose that survived into the final law. And of course, this represents a lot more than one subject. It has which courts have jurisdiction over disputes. It has the legislative bureaucracy, it has the executive bureaucracy, it has taxes, it has all kinds of things in it that should have been in separate bills. So of course some folks went to court and said this can't be constitutional. Well, in 2005, the court said, yeah, looks okay to us. That was 2 weeks before the pay raise. And in the entire year while this case was pending, there were secret negotiations between the court and the executive branch and the legislature over how to pass that pay raise. So they decide this case, 2 weeks later they do the pay raise in exactly the same way. Ron Castille's decision on the pay raise could have said, we're not going to do legislation that way anymore. It didn't do that. So today, even today, after all these years, on any given day the legislature's in session, this can happen. They can pass a law without any public hearings, without any public knowledge. There's something fundamentally wrong with that, and Pennsylvania needs justices on the Supreme Court who are willing to hold the Constitution up and say, this means what it says. 3 days means 3 days. Single subject means single subject. Original purpose means original purpose. Otherwise, our courts are no better than our legislature. That is a big reason to vote no in November.